Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur.
Today I'm going to talk about Copyright Act 1957. Let's discuss the concept and introduction. The term copyright is not defined under the Indian Cinematography Act 1957, hereinafter referred to as Copyright Act. The general connotation of the term copyright refers to as the right to copy which is available to the author or the creator, or as the case may be. Thus, any other person who copies the original work would be amount to infringement under the Copyright Act. Copyright ensures certain minimum safeguards of the rights of authors, even their creations, creativity being the keystone of progress. No civilized society can afford to ignore the basic requirements of encouraging the same. Economic and social development of a society is dependent on creativity. The protection provided by copyright to the efforts of writers, artists, designers, dramatists, musicians, and architects, producers of sound recordings, cinematograph, film, and computer software creates an atmosphere conducive to creativity, which induces them to create more and motivates others to create. On the other hand, what is created by him or her cannot be claimed ownership for generations altogether, as it might harm the social justice. Copyright as a term of life plus 60 years is being adopted in India for the purpose of determining the period of copyright. This period may vary from country to country. If copyright protection is applied rigidly, it can hamper progress of the society. Therefore, copyright laws are enacted with necessary exemptions and limitations to ensure that a balance is maintained between the interest of the creators and of the community. Copyright may be acquired for almost all the visible things like script, photo, book, essay, films, videos, architectures, etc. And also intangible things as music. The most important criteria to determine whether the said article is copyrightable or not is based on its originality. Also, copyright can only for things that are worth copying and not otherwise. For example, a baby scribbling in a pad cannot be copyrighted. Copyright protects the expression and not the content or substance per se. For example, an author writes about making an aircraft. Here, the idea of making the plane is not protected, but the way of expressing is protected. The idea is protected under the patent law and not under the Copyright Act. Copyright does not protect the titles per se or the names, words or set of words, but there can be exceptions based on the facts and circumstances of each case. For example, the actor Shah Rukh Khan has copyrights his name SRK, and the music composer A.R. Rahman copyrighted the title Jai Ho for the Oscar song, which is currently under litigation. It is noteworthy to mention here that the defendant can always take a stand of cancellation of copyright in any suit unless he is stopped by the implied or express acceptance. Copyright may also be granted for things that would come under patents, trademarks, or designs, as copyright protects only the expression and nothing more. It is much more preferred in practice, except in case of film industry. This will be dealt elaborately in forthcoming topics. Copyright is a right given by the law of creators of literary, dramatic, musical, and artistic work, and producers of cinematograph, film, and sound recordings. In fact, it is a bundle of rights including inter alia rights of reproduction, communication to the public, adaptation, and translation of the work. There could be slight variation in the composition of the rights depending upon the nature of work. Work in which copyright subsists. First is literary works, including computer programs, tables, compilations, including computer literary databases. Second is dramatic works. Third, musical works. Fourth, artistic works. Fifth, cinematograph films and sound recordings. Foreign works. The copyright of foreign works is also protected in India. Copyright of nationals of countries who are members of Berne Convention for the protection of literary and artistic works. Universal Copyright Convention and TRIPS agreement are protected in India through the International Copyright Order, as if such works are Indian works copyright as provided by the Indian Copyright Act is valid only within the borders of the country. To secure protection to Indian works in foreign countries, India has become a member of the following international conventions on copyright and neighboring related rights. One Convention for the Protection of Literary and Artistic Works, Universal Copyright Convention, Convention for the Protection of Producers of Phonograms against unauthorized duplication of their phonograms, Multilateral Convention for the Avoidance of Double Taxation of Copyright Royalties, Trade-related aspects of intellectual property rights, TRIPS Agreement. Now, let's discuss the registration of copyright. Copyright is an automatic once the original work is created, and it does not require any formality. However, certificate of registration of copyright and the entries made therein serve as prima facie evidence in a court of law with reference to dispute related to ownership of copyright. Procedure for registration. Chapter 6 of the Copyright Rules 1956 sets out the procedure for the registration under the Copyright Act. The procedure for registration is as follows. Application for registration is to be made on Form 4th, including the statement of particulars and statement of further particulars, as prescribed in the first schedule to the rules. B. Separate applications should be made for registration of each work. Third point. Each application should be accompanied by the requisite fee prescribed in the second schedule to the rules. D. The application should be signed by the applicant or the advocate in whose favor a wakalatnama or the power of attorney have been executed. The power of attorney signed by the party and accepted by the advocate should also be enclosed. Each and every column of the statement of particulars and the statement of further particulars should be replied specifically. Kindly note this point. The application should be signed by the applicant or the advocate in whose favor a wakalatnama or the power of attorney has been executed. Some of the advantages of registration are: registration establishes a public record of the copyright claim before an infringement suit may be filed in court. Registration is necessary for works. Registration establishes sufficient evidence in court concerning the validity of the copyright and the fact stated in the copyright certificate. If registration is made, statutory damages and attorney's fees will be available to the copyright owner in court actions. Otherwise, only an award of actual damages and profits is available to the copyright owner. Registration allows the owner of the copyright to record the registration with the Indian Customs for protection against the importation of infringing copies. Now let's discuss. The owner of the copyright has the following rights under Act 3. We are going to discuss 3 points here, that is reproduction, communication and adaptation. The copyright confers upon the assessee the sole right to reproduce the authored work. In other words, no other person except the author shall make copies, one or many, of the work, or copy the substantial part of the work in any form, including sound and film recording, etc. Without the permission of the copyright owner. For example, a person buys a film CD and the person makes multiple copies of it and sell it to others. This would amount to copyright infringement. The second important part is communication. Communication to the public means any work available to general public for the purpose of being seen or heard or otherwise enjoyed by the public directly or by any means of display or diffusion. It is not necessary that any member of the public actually sees, hears or otherwise enjoys the work so made available. For example, a cable operator may transmit a cinematograph film which no member of the public might have seen. Still, it is a communication to the public. The fact that the work in question is accessible to public is enough to say that the work is communicated to the public. Next is adaptation. Adaptation involves the preparation of new work in the same or different form based upon an already existing work. The Copyright Act defines the following acts as adaptations: conversion of a dramatic work into a non-dramatic work, conversion of a literary or artistic work into a dramatic work, rearrangement of a literary or dramatic work, depiction in a comic form or through pictures of a literary or dramatic work, transcription of a musical work or any act involving rearrangement or alteration of an existing work. Now let's discuss the translation of Copyright Act. Similarly, the owner has the full and the sole authority to translate the work done by him in one language to one or many other languages. Any other person interested in doing so must get the prior permission of the owner. For example, a film taken in English can be dubbed and remade only by the owner or any other person with the consent of the owner. Let's discuss the duration, that means the life of right. Generally, copyright lasts for life, means plus 60 years in India. On the screen you can see one side the kind of work that has been written and the duration of the right is written on the other side. Let's discuss point-wise. Original literary, dramatic, musical and artistic work. The duration is 60 years from the year following the death of the author. In case of joint authorship, the date has reference to the author who dies last. Posthumous work, 60 years from the date of demise of the owner. Anonymous and pseudonymous publications, 60 years from the beginning of the calendar year for the year of publication. For photographs, 60 years from the beginning of the calendar year next following the year in which the photograph is published. Work of government, public undertaking, 60 years from the year next to the year of International Organization publication. And lastly, Cinematograph Act film. 60 years from the post calendar of the release of the film, post calendar year of the release of the film. It is very important. Why? Because mostly students get confused between copyright, patent and trademark. So here in this slide I'm going to discuss what is the difference between copyright, patent and trademark. Copyright, patents and trademarks are commonly referred to as intellectual property. Each one gives the owner exclusive rights to the work, meaning the owner has the right to prevent anyone else from using their work. Each one deals in different spheres, and main difference is as follows. First, a copyright protects the expression of a person's ideas. Copyright protection is given to creative works like writings, computer programs, music, lyrics, graphics, designs, sculpture, photographs, movies, and sound recordings. The expressions must be original, which in this context means a work that is not a copy of another work. For patent, in order to qualify for a patent, an invention must be novel, which means that it is something new. The inventions must also be useful and not necessarily very important, but it must have some use and also must not be obvious. Non-obvious means a person who is in the field, posita, and understands the subject views the invention as a surprising and significant development in the field. Lastly, trademark. A trademark protects something that is used to identify origin of a product or a service. A trademark describes something and is not the thing being described. An example of trademark would be a corporate identity, such as a logo, which is placed on products to inform consumers that the product originated from the particular company. Now let's discuss few cases so that you understand the copyrights and its violations. In the case of Super Cassette Industries versus Nodules Company Limited, the defendant played cassette in hotel, amount to copyright infringement. This was clearly held to be act of infringement of author's right over copyright. Copying can therefore be proved by inference. It can be inferred that the defendant has in fact copied the plaintiff's work from the fact that defendant had access to the plaintiff's work and from the similarities between his work and that of plaintiffs. The rationale behind this is that given the sufficient opportunities that the defendant had to copy the plaintiff's work, in addition to the striking similarities between the two works, the evidence in hand is indicative of copyright infringement. In case of Roma Mitra versus State of Bihar, the plaintiff, a student, gave the work to the guide. The guide published the work as her own. The published article was substantially similar and therefore amounted to copyright infringement. In the case of TY Inc. versus GMA Accessories, it has held that similarity between works is highly unlikely to have been an accident of independent creation, that is an evidence of access. In case of SK Datta versus Law Book Company and others, the court determined the amount of substantiality should be more than half of the total work. It has also held that where the half of the work is copied and the remaining being original work, but it does not constitute infringement. If there are no similarities, no amount of evidence of access will suffice to prove copying. If evidence of access is absent, the similarities must be so striking as to preclude the possibility that plaintiff and the defendant arrived at the same result. Therefore, to summarize the condition to prove infringement can be summarized as follows. First, close similarity. Second, unlawful. Third, some connection. And fourth is access to original work. The copying need to be proved the following things. Please listen carefully. Closely similarity, unlawful, some connection, and access to original work. Lastly, I'm going to discuss the act copying by defendant may not always amount to infringement. Some examples of act which do not constitute infringement under the Copyright Act are as follows. First is fair dealing, such as criticisms, personal use, newspaper reports, review, etc. Second is adaptation of computer program. Third is judicial proceedings. Fourth is exclusive work of member of the House of Legislature. Another point is non-corporate matters for institutional purpose. Question papers are also do not fall under the category of infringement. With consent, that means giving approval to somebody to recreate the product does not come under infringement. Non-paying audiences. Audience who are not paying, that means you are not earning from the material by being publication. Issues being current topic such as economic, social, political, etc. And if somebody has made less than 3 copies. Research or private study will also not come under this infringement. It is available in official gazette. If it has been published officially, then it will not consider as an infringement. Report of committee or commission will also not consider as a infringement under the Copyright Act. And lastly, after the expiry of the copyright, that means once the duration of your copyright will be over, it will not amount to infringement. So here in this topic we have discussed what is copyright, what is the tenure of copyright, what are the benefits that a copyright person can get, what is the importance of copyright, and we have also discussed the difference between patent, copyright and trademark. And lastly, by discussing certain important cases in India, we have understood this topic in detail. Thank you so much. I hope this will help the student to understand it further. Thank you.